All right, welcome back from lunch. We are on agenda item 10, which is final action on contested in-stream flow appropriations. Rob, welcome.
Hi, good afternoon. For the record, Rob Veal, CWCB staff. I'll be presenting agenda item 10A. This is final action on the contested in-stream flow appropriation on Carnero Creek. So first, let me show you a brief timeline of the events regarding this appropriation. The recommendation for an in-stream flow on Carnero Creek was first brought by Colorado Parks and Wildlife to the in-stream flow workshop in January 2018. The board formed its intent to appropriate it this past January. S&T Farms, LLC, filed a notice to contest soon after. And then staff in the AG's office worked with representatives for S&T Farms throughout the spring and summer until a stipulation and agreement was signed on September 5th between the AG's office and representatives from S&T. This brings us to today, where staff is seeking final action on the Carnero Creek in-stream flow appropriation with the inclusion of the terms and conditions agreed upon in the stipulation. So if you guys have forgotten about what Carnero Creek was, the recommendation, here's a quick little recap of the natural environment and flow recommendation. Once again, it's a CPW recommendation and has a fishery consisting of brown trout, white sucker, and most important to CPW, Rio Grande cutthroat trout. The proposed flow amounts are 2.2 CFS from December 1st through February 29th, and then 2.6 CFS from March 1st through November 30th. So to orient you a little bit, here's a map. So on here you can see this yellow line is the recommended ISF reach on Carnero Creek. And the pink lines up above, those are existing previously decreed in-stream flows. So this ISF reach starts at the confluence of South Fork Carnero Creek and Middle Fork Carnero Creek, and it covers a distance of about 9.81 miles down to the confluence with the Magotos Arroyo. This map also shows the current location of S&T Farms diversion structures within the reach. The uppermost is the Casillas Ditch, which is close to the upper property boundary for S&T Farms. There's also the Beal Ditch, not to be confused with Veal. I know I got a little confused at first. The Susanna and Wilson ditches, and then about in the middle of the reach, there's a gauge that's been consistently operating since around 1919. Below this is the Holland Ditch, and finally, just below the Magotos Arroyo is the Omnibus Ditch, which holds some of the senior water rights in all of Carnero Creek. So in our discussions with S&T, they indicated that in the future they may want to file for a change of water rights to alternate point some of those omnibus ditch water rights upstream to some of those other ditches that is previously mentioned. The stipulation agreement set forth the conditions that S&T would follow if a formal change of water rights does occur. And now Jen Milley from the AG's office will give you a quick rundown of the specifics of this stipulation.
Thank you, Jen Mealy from the AG's office. S&T was the only entity to have party status for this contested in-stream flow right. S&T owns a ranch that is about 6,200 acres in size. It's on the downstream half of the proposed reach for the in-stream flow right. The property is encumbered by a conservation easement, which does seem to demonstrate conservation efforts by the landowner. So the omnibus ditch that Rob mentioned is the senior-most diversion in this stretch of the river. As the stipulation says, it has the practical effect of bringing water through the Carnero Creek in-stream flow reach. And like most diverters in the reach of a potential in-stream flow right, S&T is concerned about maintaining the flexibility of their operations. As Rob also mentioned, maybe they want to move some of their omnibus ditch water rights upstream to one of those other ditches, although they don't seem to have any concrete plans to do that right now. They're wondering if they might want to in the future. And the stipulation then recognizes that they might file for that change But the stipulation also recognizes a desire of the parties to keep the flows of the creek at 5 CFS when they can. So, walking through the provisions in the stipulation, which staff has recommended be part of the final action in this, in-stream flow appropriation, and staff is recommending be a part of the water court decree, ultimately entered for the water right. Paragraph 5 has the key provisions. I'll walk through 5A through D. 5A describes the omnibus ditch right and discusses the fact that S&T may want to move that, some portion of that, of those rights upstream to their upstream ditches. 5B, I believe, is the key provision here. If S&T does want to file for a change of the omnibus ditch to divert at one of those upstream ditches, CWCB can only oppose that, can only be opposer in that case to ensure consistency with the stipulation. As long as S&T abides by provisions 1, 2, and 3 within 5B. The first one being that S&T is required to maintain at least 5 CFS of the omnibus ditch water right in Carnero Creek that can only be diverted by the omnibus ditch. So even if they move some of that water upstream, some has to stay with the omnibus ditch. Second provision requires that that 5 CFS mentioned above be measured at the omnibus ditch if they're actually diverting and using that water through that ditch, and if they're not using it, then it remain in the creek and be measured at the location of the omnibus ditch head gate. And the third provision that there is when 5 CFS or less present in Carnero Creek, then the S&T must call for the omnibus ditch right down at the omnibus. They can't use any of their upstream points to call for that water right. 5C states that if the omnibus files for a change that doesn't set forth those 3 provisions, that the CWCB can file an SOP without the limitation mentioned in the stipulation, meaning that the CWCB would be able to allege injury to this in-stream flow water right as grounds for the opposition. And then finally, FD states that the CWCB can't use the Carnero Creek in-stream flow right to oppose relocation of the omnibus head gate under 3786-111. That provision of the statute states that if the channel of the natural stream is changed so as to prevent the ditch from receiving proper inflow, then the ditch owner can relocate their head gate. I don't think that we'd want to be using in-stream flow rights to prevent ditch owners from diverting through their ditch if stream conditions change so as to make that physically impossible. So I thought that was an acceptable provision to include in the stipulation. If the board agrees with the terms of the stipulation that staff has agreed to, then S&T will withdraw their notice to contest. If the board, rejects the stipulation, then the stipulation is deemed void, and the notice to contest filed by S&T is considered to be in full force and effect. We've got a hearing that's still set for November, but we will have to reset the dates for the deadlines for the pre-hearing statements and for the pre-hearing conference, and I believe we'll have to do that in the next couple days because November hearing is going to be here before you know it, and we'll need those deadlines set. But we liked the terms and conditions. We thought the stipulation was mutually beneficial to the parties, provides a cushion for the in-stream flow rate, and I think it's a good solution, in my mind for S&T because I think they're going to continue to use the omnibus ditch anyway, and so those 5 CFS should be in there. Thank you.
Thank you, Jen.
So that leaves us here at staff's recommendation. So this recommendation was amended a little bit slightly from the one-year memo just to better correspond with actual stipulation language. So that's the only change in here. But staff recommends that the board make the following determinations and take the following actions on the Canara Creek appropriation based on the information contained in staff's memo, as well as the information presented by staff both in writing and orally at the January 2019 board meeting. 1, determine pursuant to 3792 3 CRS 2019 that for the ISF appropriation on Canara Creek, the rates identified, there is a natural environment that can be preserved to a reasonable degree with the recommended water rights if granted. B, the natural environment will be preserved to a reasonable degree by the water available for the recommended appropriations. And C, such natural environment can exist without material injury to water rights. Then number 2, pursuant to ISF Rule 5F, established January 29, 2019 as the appropriation date for this water right. And then 3rd, direct staff to request the Attorney General's office file the necessary water right application and to include the terms and conditions contained in paragraph 5 of staff's stipulation with S&T Farms LLC in the water court decree for this ISF appropriation.
Great.
So I can entertain any questions and see if there's other people from the audience that would like to speak about this.
Thank you very much for that, Rob. We do have a gentleman who would like to give comment, D. Greenman, if you want to join us. D, if you could please state your name and who you're with for the record.
Sure. Thank you, Heather. I am D. Greenman with Mountain Valley Agribusiness. I do farm and ranch property management and water rights and water resource management work for several clients across the Southwest. I'm here on behalf of S&T Farms, the owners, Robert Shaw from Kentucky and Beth and Shane Temple that live on the El Cross Ranch. I want to, first of all, thank all of the CWCB staff that worked with us in trying to put this stipulation together. I think it's an example of how we can come to terms and rather quickly to allow the resources of the Water Conservation Board and the ranch to be protected. We feel like this stipulation is fair and equitable. I would like to note that we do not have any plans to move water rights up the Canaro Creek at this point in time. But agriculture and technology changes constantly, and it's changing very fast, and we may have an occasion under their ownership or a future landowner to have to move that water upstream. And we actually had a meeting that was noted up here with David Hayes and myself. David is our legal counsel. Jen Mealy, Rob B. Hill, Brandy Logan, Kara Still. Katie Birch eventually joined in. I believe she's the one that originally recommended the in-stream flow decree with Parks and Wildlife. And then later on we had Linda Bassi step in. I had contacted Heather Dutton to express my concerns when we found out about this. And CWCB definitely team players. So thank you, and I hope you can go ahead and approve the stipulation and allow this in-stream flow decree. The El Cross Ranch has a very stringent conservation easement on it already that limits a lot of things that you can do with the land. It's for agricultural use. It's through the Nature Conservancy. We have a good working relationship with them. The only other thing that I want to talk about real quick, we didn't know anything about this in-stream flow decree, we being the Temples, myself, until I heard it announced at the Colorado Water Congress Convention in January. It caught us all off guard. It caught us by surprise. And I think, especially with the Parks and Wildlife, I've dealt with a lot of those people over the years, and I'd always thought there was a good rapport between Parks and Wildlife and also the CWCB in working with landowners and letting landowners know what the state's thinking about doing. And I feel like the protocol in this particular instance cost everybody a lot of time and money. When a simple phone call or a simple stop in at the ranch and visit with the owners and let them know we like this stream stretch. Be nice if we could put an in-stream flow decree in here and protect the Rio Grande cutthroat. And so we never had any of that dialogue. As I understand it, it was announced at a Saguache County Commissioners meeting several months before it was announced at CWCB, and that was it. I think that the CWCB and Parks and Wildlife need to be cognizant of landowners. This is their livelihood, this is their home, and moving down the road, I really think that there should be some protocol on your part to be able to interact with the landowners in the beginning so that they're the first to know. With that, I thank you all, commend all of you board members for your service on the board. I've watched Heather work it, I've watched Travis do it before, and it's a tough job. And I admire all of you for doing it. Thank you.
Thanks for being here, Dee, and I think we all appreciate your suggestions. I think everyone is always trying to think of ways to improve how we function, so thanks for the feedback, and thanks also for recognizing the staff's hard work. I know that everybody on both sides worked together in a really nice way on this, so thank you all individually on the staff for your work on getting us to this point, which seems to me to be a very reasonable and good place to be. Are there any questions? Yeah, Director Prinsloo.
Yeah, I just want to thank you for your comments, and as the Parks and Wildlife Director, they're not lost on me. We have closed that loop between our field staff and our in-stream flow staff or our water staff. And so for that, I'll apologize, but that was by no means an intent. And so I would ask that we continue to have a good relationship locally. And so, as I said, it was definitely not an intent thing. We've worked on that, and we'll continue to work on that, make sure we don't have that hiccup. So it was a surprise to some of us internally too. So we got her done.
Any additional? Yes, Director Yon.
Yeah, thanks for your comments, Dee, and for coming here as well. Those are good comments and things that we need to take into consideration, so thank you very much. I was curious, though, how did you arrive at the 5 CFS?
So the 5 CFS was arrived by the Council for the S&T Farms. That's what they suggested, that provide a little extra over the in-stream flow just for different conditions within the stream that may happen to go down to the omnibus ditch. So it wasn't a number that we derived, it was one that they came up with
Okay.
and we thought was totally suitable.
Okay, all right, thanks.
Are there any other questions or comments for any of the staff? Yeah, Director Greenberg.
Thank you, Madam Chair. Just a quick question, if there were other landowners on the ditch system who might be impacted, and if so, if they've been engaged in the conversation as well?
I don't think there's other landowners on the ditch system. I think that the ranch, those were all the ditches on the ranch. There's kind of a subdivision up above this with just some houses, but not ranching up there.
Thank you.
All right. If there's no other questions, I think we have a staff recommendation in my basin.
It's in your basin, sorry.
Director Hawkins, thank you.
I was stepping up. Sorry, I lost the agenda item number in the
It's 10A.
10A. I would move to approve staff recommendation on agenda item 10A.
It's been moved by Director Hawkins and seconded by Director Yon to approve staff recommendation on agenda item 10A. Is there any discussion of the motion? Seeing none, we'll proceed to vote. All those in favor signify by saying aye. Aye. Opposed? Motion carries. Thank you again for all your hard work on that, guys.
So I'm still here. So this is Rob
Hey, Rob.
Veal, CWCB staff. You haven't got rid of me yet. This is agenda item 10B. This is final action on the contested ISF appropriations on Disappointment Creek, the upper and lower segments. Once again, I'm just going to show you a little timeline to kind of reorient you with this recommendation. This was originally a BLM recommendation brought to the ISF workshop in 2017. Staff and the BLM met with the county about the proposed ISF recommendation and agreed to, in 2017, agreed to postpone it until 2019. And we did so. And then in January of this year, the CWCB formed its intent to appropriate both segments of Disappointment Creek. Then on March 28th, the Dolores County Board of County Commissioners filed a notice to contest. This led to Western Resource Advocates filing for party status, and Southwestern Water Conservation District filed for contested hearing participant status. Then on September 5th, 2018, the Dolores County Board of County Commissioners filed a withdrawal of their notice to contest the Disappointment Creek ISFs. Dolores County had filed a water court application on February 26, 2019, that they were hoping would meet their future needs on Disappointment Creek. The CWCB was not a party to this case, and the only opposition was from the BLM. And once upon reaching agreement with the BLM and receiving approval from the Division 7 engineer, the county decided it wasn't necessary to contest the ISF on Disappointment Creek. So subsequently, Western Resource Advocates filed a withdrawal of their party status, and Southwestern filed for a withdrawal of their contested hearing participant status. So that leads us to here today, where staff is requesting final action on both segments of the Disappointment Creek ISF. So here's a quick recap of the particulars of the upper segment of Disappointment Creek ISF recommendation. Is a BLM recommendation. It contains a diverse fishery of Colorado River cutthroat trout, speckled dace, flannelmouth sucker, and round-tailed chub. The proposed flow mounts are listed in the slide up here. I don't think you guys want me to go through those. It's the same in the recommendation memo. So for the lower segment of Disappointment Creek, it's also a BLM recommendation, and it contains flannelmouth sucker and round-tailed chub. And the proposed flow amounts in this, it's important to note, are only seasonal, so it only goes from March until the end of June. So we have staff's recommendation. Staff recommends that the board make the following determinations and take the following actions on the two segments of Disappointment Creek based on the information contained in staff's memo, as well as the information presented by staff both in writing and orally at the January 29th, 2019 meeting. Number one, determine pursuant to section 3792, paren 3, that for the two ISF appropriations on Disappointment Creeks at the rates identified in the attachments to staff's memo, A, there is a natural environment that can be preserved to a reasonable degree with a recommended water rights if granted. B, the natural environment will be preserved to a reasonable degree by the water available for the recommended appropriations. And C, the natural environment can exist without material injury to water rights. 2, pursuant to ISF Rule 5F, established January 29th, 2019 as the appropriation date for these water rights. And 3rd, direct staff to request the Attorney General's office to file the necessary water right application for these ISF appropriations. So that's all I have. I can entertain any questions if you have them.
Thank you, Rob. Are there any questions for Rob? Director Trick?
Is anyone from Dolores County or the district or Western Resource Advocates here, and do they want to address this matter at all, or?
Not that I'm aware of.
Okay.
Unless.
Director Hawkins?
Thanks, Rob. I first of all want to acknowledge the amount of time that the CWCB staff has spent working with the county and the BLM on this. I know that that it took a little extra time and some extra meetings down in Dove Creek, and I think that it was well worth taking that time to do this. I have to say that I don't always look forward when I get called into a public meeting to talk about in-stream flows, but going down to Dove Creek to talk to Dolores County has always been a real pleasure. The dialogue around this in-stream flow was really good, and I think that people on both sides learned a lot, and I appreciate Roy Smith with the BLM really sticking with us on that. So with that, I would move to approve staff recommendation on agenda item 10B, except for I would like you to fix the typo in provision 2.
To these water rights.
Yes.
Yes.
Okay, great. It's been moved by Director Hawkins and seconded by Director Brody to approve staff recommendation on agenda item 10B. Is there any discussion? Seeing none, we'll proceed to vote. All those in favor signify by saying aye. Aye. Opposed? Motion carries. Thanks, Rob.
Okay, so I'm still here, but this is the last you'll hear from me today. So this is agenda item 11. This is an informational item only, and I won't even be talking much on this item. So this is the Abrams Creek project update. So Abrams Creek, if you remember, the board got an increased in-stream flow last year on Abrams Creek, and it's also part of a irrigation efficiency project. And to give you a little bit of a presentation is going to be John Hill from the Buckhorn Valley Metropolitan District and Melly Whiting from Trout Unlimited.
Welcome.
Hi, everybody. We're dressed casually today because we're not asking for money. Rather, we're happy to be here to kind of run a victory lap and tell you that we've completed the project on time and on budget, and show you a little bit about what we did, and to thank you for your support. Without your 2 appropriations, we would not have been able to do it. We put together with you guys a little over $1 million. Melly found another couple of $100,000. The district put $400,000 in it, and it's done, and we're going to show you what it looks like.
Melly Whiting again for the record, and just to show you that I don't just show up to ask you for money. Sometimes I show up to show you what we do with the money that we ask for. So this is an occasion. So instead of talking about it, there's a couple of videos, and you probably are getting tired of hearing people talk anyway. There are a couple of videos that describe the project, and then we can answer any questions. So if we can just go ahead and move to the first one. And this one is more done for the public.
The fish in this stream are a lineage of cutthroat trout that is indigenous to the Eagle Valley, which means that they were here before we were here. What we found out is in the Eagle Valley, this is the only population that we know of that originated here. Every other cutthroat population that we know of was introduced in some way. Something that's really special about this Abrams Creek cutthroat is that this fish has adapted to warmer climates. The thought is that by protecting Abrams Creek fish population, we'll be able to grow and expand, and we'll be able to take those and reintroduce those throughout the Eagle Valley and maybe even beyond. Then we're going to have this fish that can survive climate change better than the fish that we have out there now that aren't native.
In, I believe it was 1902, a fellow by the name of J.P. Olson constructed a ditch from Abrams Creek to the Buckhorn Valley property so we could irrigate crops and whatnot. So for that neighborhood, this is our water for our landscape. Early on in the project, it was discovered that Abrams Creek has one of the genetically purest forms of Colorado River cutthroat trout.
Parks and Wildlife, they were concerned about, having enough habitat for their survival. The JPO ditch diverts a lot of water, sometimes even drying up the stream. So they approached the district to see if there was some way that we could leave more water in the stream for the fish. And that's where the conversation started. That's where the discussion started. That's where we landed with an agreement that works for everybody.
Buckhorn Valley Metro District, Colorado Parks and Wildlife, and Trout Unlimited all kind of banded together to come up with ideas and ways that we could get historically as much water as Buckhorn Valley has been diverting out of Abrams, and also at the same time leave more water in Abrams Creek.
It is a valley
valuable water right, it is a valuable fishery, and this project just helps both. And what the project consists of is basically building a pipeline to divert water from Abrams Creek.
By putting this pipeline in, it makes sure that we don't lose water in the ditch and that we are using our water right in a safe and efficient manner so that we can provide those fish with that optimal habitat.
Improving that efficiency is really exciting. That gets more water where it was supposed to go for the ditch and also keeps more water in Abrams Creek itself. And that protects habitat and protects the fish, which is what we're looking to do.
They're leaving 40% of the water that they could have diverted and have diverted in the past. They're leaving it in the stream for the fish. They're also agreeing to leave a minimum flow there so the creek never dries up again.
We're very, very thankful for the landowner to give us an opportunity to work with this land and allow the water to flow better and work. It's a definite win-win situation here. We're making sure that we don't lose water along the way through Hernage and Abrams, and that's helping us, making sure that we keep water in our reservoir and make it to where future generations can fish there.
It's also a win for Trout Unlimited and Colorado Parks and Wildlife. We are in the process of helping to restore habitat for a very important species of fish.
It's become apparent for everybody that we need to protect and preserve areas such as this and promote a healthy environment for future generations.
Getting families out, getting kids away from the screens and out recreating with their family and their friends and fishing. I mean, that's a zen moment for most anyone that likes to fish, and it's a spectacular thing that we can offer to the community through this project. Trout Unlimited is very, very proud to be a part of this project because it shows what we can accomplish working together with other water users, and we get to protect this very rare and beautiful fish.
So the next one is shorter, promise. No slides today, but this one shows you a little bit about what it looks like at the headwaters when it's finished. And by the way, I'd note that those kids were not fishing in Abrams Creek. There you go. This was made by the local newspaper.
Hello and welcome to the Vale Dailies on the Hill. I'm John LeConte out at Abrams Creek right now with Kendall Backish of Colorado Parks and Wildlife. We are at the end of a pipe project which will be piping water from Abrams Creek down to the Buckhorn Valley Metro District at a savings of 40% of the total water in an effort to help a rare cutthroat trout.
The fish in Abrams Creek are a very unique subspecies of cutthroat trout. They're the only indigenous population of cutthroat trout in the Eagle River watershed. There is not another population that has been here since the beginning.
So we installed a pipeline, and that is much more efficient. So 40% of flows that would have gone down that pipeline are staying in the creek, and that's the big project.
Yes, and there are times of the year that they could have taken the whole stream
Right.
and removed all the water for the fish. The agreement that Trout Unlimited, you guys, and Buckhorn Valley entered into protects that water for the stream. They promise they won't take it. We've also identified a flow rate that is best for maintaining habitat for the cutthroat that is improved from the historic in-stream flow. So what would typically happen is water comes in through here, it goes over the screen, and it drops through the screen.
Okay.
So that will catch any debris, and then the extra water will actually push that debris off the screen. And then if any fish are coming over too, those fish will slide right down and go out the channel. They actually saw it prove itself by having the fish swim up the screen and into the pool.
So the fish came in the wrong way. He got a little lost in there, but then found his way back under,
Yep.
right under there, and into this pool. You witnessed that it it's gonna work.
Yeah, it is. So within 10 minutes we had a fish in here and no problems. Worked just like it should.
So one thing you might have seen in the background there is your Jay Landers? Jack, putting together, the last piece was a upstream flow measuring device, which your folks, Jack is putting in or has put in, he's putting telemetry in now. And that was funded by U.S. Fish and Wildlife, right?
It's a mix of funding.
Okay. Anyway, so there's one last little piece of measurement done. The stream is almost non-existent at this point in the year, so they're finishing that up, and then next year will be fully operational. And we really appreciate your help on this.
So the Buckhorn and Trout Unlimited's agreement goes in perpetuity. It runs with the water rights and it has been recorded. And the other piece of this is that you all have appropriated 1.25 CFS in-stream flow right to protect the stream for the future. There was already, I think it was a 1 CFS, and we added 0.25. Or was it 0.75? Okay. So it has those protections. And I just finally wanted to just say that, just acknowledge Buckhorn District, and particularly John Hill. You know, it was a long process to come to an agreement on doing this and quantify what is it that we were gaining here. It took a long time. I don't know if you can hear me, John, but thank you. It's been a great partner, and we need to find more folks like this to do this kind of project. And thank you for the CWCB for all your support.
Thank you, John and Melly. Are there any questions for this group? Thank you guys for sharing those great videos. We just needed some popcorn. Jim and I were hoping that there wasn't going to end with a campfire scene and eating some fish, so that was good. But really, we appreciate you guys coming back and sharing the story. It's really fun to approve grants and get to dream a little bit with you about what you're going to do, but it's really cool to see you bring it to fruition. So thank you for being here and for sharing your story.
Thank you.
Okay, we are on to agenda item 12, which is the rainwater harvesting pilot project update with Ryan. Welcome back.
Thank you. Thanks. For the record, I'm Ryan Gilliam. I'm a grad student at Colorado School of Mines and an intern with DWR and CWCB. We presented to you in in July on the bulk of the technical work behind the development of these regional factors that we have today for your approval, along with the revised criteria and guidelines. So I'm going to start with a very brief recap of the factors that we developed to estimate historic natural depletion for the operational approval of these pilot projects. And then I'm going to walk you through the feedback that we received from the public and the work that we did to address the comments that we received from the board in July, and finally review the updates to the criteria and guidelines that we made. So public comment, there was one formal comment submitted by Western Resource advocates in support of the policy. In the outreach presentations that we conducted, we had a lot of really positive informal feedback and conversations and interest in the pilot projects and optimism that the factors might help some developers get on board with the projects and take them underway. We did take Director Dutton's recommendation to get on the Water Congress agenda. Unfortunately, last minute I was ill and not able to present, but we did appreciate that recommendation. Going into the board comment that we received from Director Yan asked about how vegetation and high angle slopes might impact the estimates from the factors. For vegetation, the factors assume that vegetation on site at the pilot project contributes significantly to historic natural depletion. So we've added a requirement in the application process to submit photos of the pilot project site to demonstrate the presence of native vegetation. the question of slope and how high-angle slopes might increase runoff, thereby decreasing infiltration and natural depletion. We didn't make any updates to the factors. We conducted a little bit more research and communicated with Director Yan about this. But the primary drivers of runoff and infiltration in semi-arid environments like Colorado are precipitation intensity and infiltration parameters of the soil, which are exactly what we have in the factors. And additionally, the conservative modeling assumptions we used in their development should account for any impact from this. The next revision that we made from board comment was Director Brown's question about the map of rock outcrop and limitations of where the factors can be used. We revised this to require the use of the NRCS web soil survey for the hydrologic soil groups. Rock outcrop is classified as soil group D, which is one of our factors, but the names of each map unit soil are also tabulated in the web soil survey and other formats of the NRCS data. And so that textual naming can be used to exclude rock outcrop areas from the estimation of historic natural depletion on a project-by-project basis. A screenshot of the user interface of the web soil survey. It's something that I expect would be familiar to anyone that would be working on one of these projects of how to use the data. And even someone who's not, it's a pretty straightforward system to use and download all of that. And finally, the updates that we made to the 2019 criteria and guidelines, as reviewed in the board materials, we updated it to include the historic natural depletion factors, a little bit of context and overview of how they work, directing users to the full technical report for further detail. We eliminated the annual March 1 application deadline because there's not a massive amount of applications coming through, so batching them doesn't seem necessary. We reduced the annual review fee from $7,000 to $1,000 on consultation with Kevin Reedy at CWCB, who is responsible for those reviews. And finally, again, in consultation with Kevin, we updated the landscaping and irrigation recommendations to encourage pilot projects to work with landscape and irrigation designers who are certified by an EPA WaterSense labeled program. And with that, I thank you for your time, and I'm happy to take any questions along with Tracy and Kevin on more legal and administrative matters.
Thanks, Ryan. Are there any questions for Ryan about her update? Director Ryan. Yeah.
And I forgot to mention this is an action item, and we have a staff recommendation for your vote to approve the revised criteria and guidelines.
Great. Seeing no questions, let's get the staff recommendation.
Okay. Staff recommends that the board adopt the proposed updates to the rainwater harvesting pilot project criteria and guidelines.
Okay. Director Yan.
All right. Thanks, Ryan, for coming back, and thanks for incorporating some of our questions and making a few changes. I appreciate it. So with that, I would move staff recommendation on agenda item 12.
It's been moved by Director Yan and seconded by Director Goebel to approve staff recommendation on agenda item 12. Is there any discussion? Director Ryan.
Thank you, Madam Chair, and I want to recognize Ryan for her great work on this. It's a real privilege to have someone as an intern come in and do this high level of work. But I also want us to remember that that Ryan also worked under Deputy State Engineer Tracy Kozloff's direction on this. And Tracy was given this responsibility some time ago as our one pilot project was developing data and getting us to the point where we could actually develop regionally applicable factors. So I don't want to forget that Tracy did a lot of work to facilitate the direction and progress on this. So thank you both for that.
Thank you, Kevin.
Any other discussion on the motion? Seeing none, we'll proceed to vote. All those in favor signify by saying aye. Aye. Opposed? Motion carries. Thank you. Thank you all for your work. Okay. We are now on to item 13, which is Colorado River 101. Looks like we're going to have the dream team up here.
Thanks.
Good afternoon, everybody. Karen Kwan from the Colorado Attorney General's Office. I'm just going to introduce this topic and then let the A-team of Amy Ostick and Lane Leoniak actually do the presentation. But just to kick it off, there's been a few issues on the Colorado River that you guys have had to come across recently, so I've heard. And I just wanted to touch a bit upon the concept that you may recall in July, for example, we were talking about the compact compliance study, and Director Goebel had indicated, and I think it'd be very beneficial for the entire board to get more in-depth information and results from that. I think for that to be beneficial, as well as to be beneficial in the other areas of the Colorado River that are before the CWCB, that we lay a foundational understanding of issues on the Colorado River. And as I've worked with Director Ryan on occasions, it's layered. There's ways to get at this in a number of methods, but I've been working on it for 15 years. I know people who've been working on it for 50 years, and it still takes time and energy to figure some of this stuff out. So we're going to do this in layers. This is not the only time. And I also would remind you guys that we gave you a background kind of reference document. There's no test on that. We're not going to quiz anybody on that. And it's an informal summary. We did not capture everything. I would say one glaring thing that is hugely absent from it that warrants its own workshop is the concept of tribal settlements and the tribal rights to water on the Colorado River. We wanted to give that its own due importance. So we're not touching on that right now, but that's intended to be a reference document for you guys to kind of just look at when you want to, and if you ever have any questions or concerns or wondering how things go, then you can come up to us and we can talk about it. And what we're going to do today is try to glean some of this stuff out of that reference document and highlight for you to provide that foundational background. So to that end, we have a timeline that I'm going to show you, but it's broken out into 3 different segments of what the law of of just stuff that's happened on the Colorado River that kind of guides our operations and our thinking. The first section of it is the law of the river, the collection of compacts, laws, decrees, federal regulations and agreements and all of that that govern use and management of the Colorado River. There's other relevant laws that definitely influence Colorado River management within the basin that aren't specifically law of the river. They aren't specific to managing and operating the reservoirs directly. But NEPA, the Endangered Species Act, things like that overlay and influence everything. So those are other relevant laws. And then there's the regulations and agreements. How do you actually implement the laws? The Secretary of the Interior might implement regulations, such as the 2007 interim guidelines, or the states might enter into agreements, such as the drought contingency plan, those kind of things that lay out. So that kind of comes to this situation where we're going to have a lot. I'm just going to plow through them. So if you want to know the history of the Colorado River and what we work on and what we look at, this is all of it. And this is kind of what we summarized in the reference documents to you guys. So we have this timeline, and this timeline is attributable to Russ Sands, because I don't know PowerPoint nearly as well. And he kind of was like, sure, I'll do this for you. So it's all him. And so thanks for the Swazi update and everything, because that helps us. We'll have this as a visual for you guys, but the blue is the law of the river, the light blue or green is the other relevant laws, and the oranges are the regulations. These all are things we have to constantly keep in mind when we're talking about working on the Colorado River. So that's kind of just the overlay. Now I'm actually going to have Amy and Lane tell you what it all means.
Not quite. Hi, I'm Amy Ostick, and this is my first opportunity to introduce myself as CWCB staff. I'm really excited to be here, and I thank you all for the very warm welcome. Director Yon did ask if I brought any deer meat to share. Unfortunately, I don't have any today, but if you go down the road about 30 miles, you might be able to find some. So, there's more. So since I'm no longer in my role at the Attorney General's office, it's my task to present you with some good cocktail hour facts on the Colorado River. Excuse me. So the Colorado River supplies water to 40 million people. It provides water to some pretty big cities, including, of course, Denver and Phoenix and LA and a few others. It irrigates 5.5 million acres of farmland. It provides water to 22 tribes. to national wildlife refuges, parks, recreation areas, and monuments. And it is responsible for 1.4 trillion economically. So that's kind of big picture, but what does that mean for Colorado? So the majority of water consumed in Colorado comes from the Colorado River and its tributaries. And 70% of the flows of the entire Colorado River originate in Colorado, which makes the interstate cooperative elements of all of this pretty important. So that being said, there are a lot of stakeholders that care a lot about the river, in addition to the 7 states that have an allocation on the Colorado River. The Republic of Mexico also gets 1.5 million acre-feet of water from the river. And when we do anything on the river, we need to think about consultation with a wide range of stakeholders and interested parties. So as we kind of talk about and think about the Colorado River, we've thought about it as a Jenga game, I guess. And that's because to say that the Colorado River implicates a lot of complex and nuanced issues would be a huge understatement. It touches on a lot of things. So the way we think about it, if you kind of pull on one of those strings or pull out one of those blocks, it could affect a lot of other things. And we're trying really hard to not let the whole thing come tumbling down. That's our goal. But we need to think about kind of the big picture and think about it holistically when we take any actions on the river. So for Colorado, some of those big picture questions include, are we going to be able to continue to rely on our Colorado River source? Will we need to curtail uses at some point in the future along with the other upper basin states? And really what this comes down to is what do we need to do to protect our interests in the Colorado River in Colorado? So as Karen kind of alluded to, there's a huge complex legal framework that goes into allocating the use of Colorado River water that we need to consider when we talk about this. And in addition to that, we're looking at pretty challenging and variable hydrology as we've seen in the last 19 years. So Lane's going to come up now and talk a little bit about the Colorado River Compact.
Good afternoon. Lane Leoniak, Colorado Attorney General's Office, the Federal and Interstate Waters Subunit, or Unit rather, the Colorado River Subunit. I don't want to say that the less fun slides have started now, but they're just fun in a different way. So, okay. So the purpose of the compact really started out of a desire to just increase security and reliability amongst the states for supplies out of the Colorado River. And that was the one thing that everyone agreed on. And that was really driven by a U.S. Supreme Court case in 1922, Wyoming versus Colorado Supreme Court said, hey, you prior appropriation states, from now on, all of your interstate affairs are going to be handled via prior appropriation. And the upper basin states and Arizona, everyone who wasn't California became concerned by that ruling because they looked at California as the 800-pound gorilla in the room. They were developing very quickly. They had far more resources. And so everyone became very concerned. So this was a key driver in wanting to sit down and try and reach an agreement to allow the states that were developing more slowly with less population time and some protection, some carve out in those supplies for themselves so they wouldn't be in a rush to develop because they knew they would lose. It also provided an equitable division, or the hope was that it would provide an equitable division, something that would be considered to be fair. And remember, when we say equitable apportionment, it's whatever folks agree to. It's whatever that apportionment is deemed to be fair. It was also perceived as a way to maintain state sovereignty and autonomy over control and distribution of the river itself, and not have to be subject to some sort of mandate by Congress or a federal agency. And it was intended to promote neighborliness and to prevent future controversies and conflicts. So what does it do? It does a lot of things. It is a very hard-working document. It is still a very hard-working document. It is the absolute foundation for everything that we do today. So first and foremost, and we're not going to go into every provision, we're just going to kind of touch on the high points. First and foremost, it defines the Colorado River system as that portion of the Colorado River and its tributaries. That's Article 2A, super duper important point. It divides the right to beneficially use the Colorado River water between the upper and the lower basins. The states couldn't figure out how to apportion it amongst themselves, so Herbert Hoover just came in, drew a line, and said, you're the upper basin, you're the lower basin. It gave the upper basin the exclusive beneficial use of 7.5 million acre feet per year to the upper basin. It gave the lower basin the same, plus an additional 1 million acre feet to develop over time. It also required the upper division to not allow for the depletion of flows at Lee Ferry to drop below 75 million acre feet over 10 consecutive years. That's what we call our non-depletion obligation to the lower basin. It also provided that any water required to be delivered to Mexico, we didn't have a treaty with Mexico at this time, but it was anticipated, it had been talked about. So because they didn't know the details of the treaty, but they left a placeholder in there that said, all right, in anticipation of this, then those supplies are going to come out of surplus from the river itself. And if there is a deficiency, it shall be equally borne by the upper and the lower divisions. It also provided that the states of the upper division shall not withhold water, and the states of the lower division shall not require the delivery of water, which cannot be reasonably applied to domestic and agricultural uses. And finally, it stated that present perfected rights are to be unimpaired. There were a lot of questions that continue to remain outstanding with regard to what some of these terms and conditions mean in the compact itself. And some of the sticky ones that we'll bring to your attention today are, what are present perfected rights? In Colorado, under Colorado state law, we have rights that are conditional, haven't been placed to beneficial use yet. We have absolute water rights that have. We have rights that were decreed for one purpose at one point in time, but subsequently have been changed to another purpose at a later point in time. Are all of those present perfected rights? Where do they fall? And what does it mean to leave them unimpaired? Again, is it a snapshot frozen in time? Yes, it was decreed for irrigation in 1919, and that's what it stays, not subject to a change. We don't know. When can water reasonably be applied to domestic and agricultural uses in the lower basin? Lower basin argues quite strenuously that under the compact, if water is not required by the upper basin to meet our needs, we are required to release it to them for their use. We would see it a bit differently here. How do you interpret all of the sub-articles of Article 3 together? There's a lot going on there. The 7.5 million acre feet per year for each basin in perpetuity. And then there's this 1 million additional acre feet. Where's that coming from? And then the deficiencies to Mexico. How does that factor in? So once the compact was ratified by some of the states, Congress stepped in because not all of the states had signed off on the compact. And so the Boulder Canyon Project Act was Congress's way of moving things along. And this was able to occur because California had finally agreed that it was going to stay within its 4.4 million acre foot allocation. And so every other state except Arizona ratified the compact. And Arizona was still concerned. They didn't think that the compact provided sufficient protection for them against development in California. They're like, great, upper basin, you guys got your carve out. We didn't get our carve out. So they were still concerned about that. And they were also very concerned about their still wanting to basically have sole access to use of the Gila River, a major tributary to the Colorado. But the act also authorized Hoover Dam and the All-American Canal. That's a picture of the concrete frames and the concrete being poured in the Hoover Dam. It's a lot of concrete. It's a big dam. It also suggested some lower basin apportionments of the 7.5 million acre feet because the lower basin couldn't decide on how much each one of the lower basin states was to receive. And then it also established a mechanism for the Secretary of the Interior to enter into contracts with water users for storage and delivery of water from the soon-to-be-built Hoover Dam. And then it also made the Secretary of the Interior the water master for the lower basin because, again, the lower basin states couldn't figure something out amongst themselves. So then finally in 1944, we get the treaty with Mexico. This then solidifies the terms and conditions with which we need to deliver water to the Republic of Mexico. So Mexico got 1.5 million acre feet guaranteed per year. If there was surplus, it could be officially increased an additional 200,000 acre feet for a total of 1.7. The treaty also talks about, in an extraordinary drought, Mexico's allotment will be reduced by the same proportion as uses within the United States are reduced. It established the International Boundary and Water Commission to implement the treaty, and then it provided for something, a process to agreement to minutes that would further define and fill in any gaps within the treaty itself to implement the terms of the treaty. Minutes are not intended to amend or alter the treaty in any way. It's just a vehicle in which to implement the treaty. So now we're starting to get some layers here. We've got the Colorado River Compact, we've got the Boulder Canyon Project Act, we've got the treaty with Mexico. So going back to the Article 3 of the Colorado River Compact, what constitutes a deficiency in the system that would trigger Upper Basin's delivery obligation to Mexico? And half. Okay, yes, half of 1.5 million acre feet is 750,000 acre feet. But is that the right amount? How is use in the lower basin tributaries accounted for? Is it reflected in the additional 1 million acre feet that the lower basin gets to develop under the Colorado River Compact? Does the lower basin's overuse, that structural deficit issue that we've talked about with you before, does that come into play? Does the upper basin's unused apportionments come into play? Is there, in fact, a deficiency in the system when the upper basin hasn't fully utilized all of their apportionment? And then what constitutes extraordinary drought? The treaty does not define that term. That's a weighted phrase, right? And it's important to keep in mind that the treaty with Mexico wasn't just as to the Colorado River, it was to the lower Rio Grande and the Tijuana River. So does this apply, does any definition as to extraordinary drought apply to the lower Rio Grande as well? So how, or can there be an extraordinary drought if there, and no deficiency within the system itself? So just to give you a visual of all of this pulling together now, here is the breakdown. You got the upper basin and their 7.5 million. The lower basin, their 7.5 plus the 1.5 to Mexico. Total allocation is 17.5 million acre feet. Interesting note, the most recent 30-year average of unregulated inflow into Lake Powell is 10.8 million acre feet. So just that's a fun fact to keep in mind. And I'm going to turn it back over to Amy Ostick.
So as Lane made clear, the Colorado River Compact of 1922 did a lot of things, but it did not allocate that 7.5 million acre feet of upper basin water, nor did it with the lower basin. The lower basin states couldn't figure things out on their own, as Lane presented, and they needed some help from Congress. In the upper basin, we're very proud of the fact that we were able to agree on a compact amongst ourselves. And here is the Upper Colorado River Compact of 1948. It does a few important things. Notably, it allocates that 7.5 million acre feet of upper basin water that we get through the compact. Colorado gets 51.75% of that. It also creates the Upper Colorado River Commission, which each of the upper division states are part of. One thing you'll note is that Arizona is not an upper division state. It's not a member of the UCRC, but it does have an allocation out of the upper basin. So essentially what happened is the upper division states told Arizona, here's a bit of water, now go away, you don't get to be a part of our party. So what does the Upper Colorado River Commission get to do? The bulk of what they do is make findings. And a lot of those findings have to do with our leaf area obligation, our compact obligation. They are authorized to make findings on leaf area deliveries, as well as the necessity and extent of curtailment if one is required in the upper basin states. And one important thing to note here is that the UCRC does not get to tell the upper division states how to actually manage that curtailment if one is called for. That would be up to the states individually. Here in Colorado, our state engineer's office. One other thing that the UCRC is authorized to make findings about is extraordinary drought. As Lane kind of raised, that term is not really defined. So just a few questions that are raised by the 1948 Compact. I'm not going to go over all of these, but I think that the important things to see here, like I said, the UCRC has the authority to look at overuse if there's a curtailment situation. And the compact provides that any state that has overused in the preceding 10 years must supply a quantity at leaf area equal to its aggregate overdraft. What does that mean? How do you determine that? A lot of questions there. In addition, if we're looking at a curtailment, the UCRC, there's going to be a proportionality of curtailment. And that will be based on the consumptive use of each state in the year, in the preceding water year, excluding use of water under rights perfected prior to November 24th, 1922. So you might start to see some open questions and some inconsistencies here, and that's kind of what we're trying to point out. So the next big thing that we're going to go over is the Colorado River Storage Project Act of 1956. And the goal here was really to provide the upper basin states with the ability to develop their compact allocation. It authorized the construction of some pretty big projects like Glen Canyon Dam, Aspinall, Flaming Gorge, Navajo. It also recognized the importance of hydropower generation and created the Colorado River Basin Fund. And you may recall Lane talking to you about that a few times up here. So the next exciting thing we'll talk about is a Supreme Court decision from 1963 of Arizona v. California. And the first thing I'm going to say about this is that it did not interpret the compact. This was a Supreme Court case among the lower basin states, and the court explicitly said that this was not an interpretation of the compact. So that's really important to remember as we go through all this. The first thing it did is it recognized Congress's authority to allocate that lower basin water. It also defined present perfected rights as water rights existing as of June 25th, 1929, and also provided a definition of consumptive use. So,
To that, why are present perfected rights as of 1929? Just to go back, the Boulder Canyon Project Act was approved in 1929, and it authorized the effectiveness of the compact after California ratified it under a 4.4 agreement and 5 other states did. So that's when the compact actually became effective, was 1929. So then the lower basin couldn't agree on what their allocation was, and they had to go to court. And the court came down and said, well, if it's present perfected rights, it has to be at the time of the compact, and they've decided the time of the compact was June of 1929, not when we signed it in 22. So,
thank you, Karen. So again, I'll just say it one more time. The Supreme Court in Arizona v. California did not interpret the Colorado River Compact. Say that. But it did allocate or uphold that allocation of 7.5 million acre feet in the lower basin, but only from the main stem of the Colorado River. If you recall, as Lane said, the Colorado River allocated the Colorado River system, which includes tributaries. So there's kind of an open question of how you reconcile Arizona v. California and its allocation of 7.5 million acre feet of main stem water with that 7.5 million acre feet to the lower basin in the compact of not only main stem water, but also tributaries. You'll learn how to use this pointer at some point today.
Okay, Okay, so after Arizona v. California decision came out, Arizona and the allocations had been made. Arizona needed federal authorization and funding for a distribution system. So the Colorado River Basin Project Act was authorized, and that granted authority to construct and fund the Central Arizona project. That basically has the capacity to divert or utilize 1.5 million acre feet of Arizona's 2.8 million acre foot allocation. That's a snapshot of it there. That's basically what it is, and it provides water, 336 miles of canal, open canal, to about 80% of Arizona's population. So it's very important to Arizona. But it also did something else that the upper basin is very important to the upper basin. It directed the secretary to authorize storage and releases out of Lake Powell in a particular order of priorities to help the upper basin meet its various obligations under the Colorado River Compact, under the treaty with Mexico. And so priority number one is releases to Mexico. So that is the number one priority in which releases are made out of Powell. Releases for that 75 million acre feet over the 10 consecutive years. Article 3D, our 75 and 10 non-depletion obligations, that's priority number 2. And then we were also to be basically have enough water stored at any given point in time to satisfy our delivery obligation to Mexico, our 75 and 10 non-depletion obligation, and enough water so as not to impair upper basin development of their various compact apportionments. And that's what we call our 602A storage. The act also allowed for equalization releases. So once all these 3 priorities are addressed and satisfied and additional storage exists, then Powell releases could be made to accomplish Article 3E. That's the one where we can't withhold and the lower basin can't call for water that they can't reasonably place to beneficial use. So that's Article 3E. To also help balance the storage elevations in both Powell and Meade, to keep them from seesawing and increase the risk of one of those reservoirs crashing, and then to prevent spills. Note that these equalization operations were not intended to release water below that 602A storage level. Out of that act, the Secretary of the Interior was also authorized to develop long-range operating criteria for the upper basin reservoirs. And so as part of that, they identified a calculation which would set the amount of water that was necessary to have the upper basin be able to continue to meet all of its needs and protect the upper basin from curtailment during dry years and allow the upper basin to continue to develop its compact apportionment. It's important to note that that number, that calculation was based on current and projected future uses. So another point is that when the whole idea was when storage levels were low in Lake Powell, then water would be preserved in Lake Powell, and we would be looking at limiting releases from the reservoir to an objective minimum. And so the long-range operating criteria set the minimum objective release at 8.23 million acre feet per year. So when reservoirs are low, this is our baseline release under the LROC, and that's 7.5 million acre feet, plus half the deficiency for our deliveries to Mexico, and minus inflows from the Pryor River, which they calculated to be somewhere, 20, 30,000 acre feet. So that's how we got to that 8.23. And honestly, we were doing okay. I mean, we had the drought in 77, we had a drought in 80, 81, but by the end of the 20th century, the reservoirs were full. Whether there needed to be a declaration of storage in the shortage in the lower basin between the issuance of the long-range operating criteria and 2000, no shortage was ever declared by the Secretary of the Interior. But again, those reservoirs were full by 1999, 2000. And then 2000 happened. And if you're a water manager and you see this, you're not sleeping at night. This is concerning. They started to drop off a cliff. Lake Powell started to drop off a cliff. And if you look at these percentages of the 30-year average between 1971 and 2000, you're getting 62%, 59%, 25%. That's not sustainable with the level of releases, even at that minimum objective release amount of 8.23. You're not going to cut it. This thing's going to go in the mud. So this is what drove the 2007 interim guidelines and those negotiations. As you can imagine, tensions were incredibly high on the river at this time, and the risk of litigation was incredibly high as well. Oops, wrong way. So the guidelines were developed, and they were basically an interim agreement in order to gain some experience on the river. Everyone agreed we can't keep going the way we've been going. We're not going to get there. We need to reach some kind of an agreement. Let's do this on an interim basis, and we can adjust as needed, either during the period of the guidelines or subsequent thereto. So it set shortage criteria for the lower basin for the first time, and it was based on certain elevation levels in Lake Mead. So if Lake Mead got at 1075, then the lower basin was responsible for generating 333,000 acre feet in conserved water. And it was assumed that Mexico would also be participating in these shortages, again going back to that treaty language, that they would take shortages in proportion to U.S. shortages. Whether or not that's triggering the definition of an extraordinary drought or not, that was not addressed here. But it did recognize Mexico would participate. There were lots of ways in which the lower basin could generate that conserved water through intentionally created surplus, or ICS. Probably the most common, the most effective was fallowing and ditch lining in the large irrigation projects in the lower basin. There was a cap of 2.1 million acre feet total to be generated pursuant to the guidelines. The other thing that the guidelines did is it further coordinated reservoir operations between Lakes Powell and Lake Mead when water supplies were low. So this is just a snapshot. This table is in the interim guidelines. This is how Lake Powell is operated. There's a counterpart for Lake Mead. And so it's based on elevation tiers. And when a certain elevation is reached, then we're in that particular tier, and that calls for certain releases to be made in certain amounts. Notice that in that mid-elevation release tier, it allows for releases less than 8.23 million acre feet to be made. So we have the ability to drop below that minimum objective release through the guidelines. This table off to the right is the equalization table, and that's really the upper basin. This was agreed to by all the parties, but this is the elevation in Lake Powell that when it gets hit, that's our elevation that's to accommodate for 602A storage for our Mexico delivery obligation, our 75 and 10, and to allow for the upper basin to continue to develop its allocation unimpaired. And if you notice, the elevation increases by a couple feet every year. That's to account for current and future projected uses and demands in the upper basin. Yes?
So were the reservoirs not operated together before the interim guidelines?
They could be operated together, and it was really in the equalization releases under the LROC when storage was quite high. So that was really the first effort. There was a second effort with some surplus guidelines that we're not talking about today, but that really was the initial effort. This really drilled down on that further with these tiers to really coordinate efforts when the reservoir levels were low. So they had thought of coordinated efforts when the reservoirs were high, not really drilling down when they were low. So this is the first effort to really drill down on that.
And to illustrate that, what would happen before this, the upper basin was required at a minimum to release 8.23 million acre feet, even if we got 25% inflow. We had, and that wasn't legally required, but that was what that's what the regulations had set up, and we had pushed back and saying that's not necessarily required, but that's how they were operating. What happened is you get 2002, and Powell's storage tanked. Mead was fine, right? But as we start to recover, we don't have to do equalization releases, and we're only doing 8.23, so Mead starts to go down. So you had the seesaw effect of PAL then Mead, and what they were trying to do is coordinate a little bit so they were going like this. So that's the difference.
So the guidelines, there were a lot of benefits. There are a lot of positives to these guidelines. First of all, we learned a lot through the operation of the guidelines, and we will know more going forward. But we also gained the ability to reduce releases when reservoir storage levels are low. Again, we actually did release less than the 8.23. We released 7.48 down to the lower basin pursuant to the guidelines when storage levels were low. It recognized for the first time that there were shortages in the lower basin and that the lower basin had to take responsibility for those shortages. And again, as Karen was saying, you know, it's intended to help stabilize the system, to prevent that seesaw effect between the two reservoirs, which increases the risk of one of them crashing. It also avoided litigation. We were on the brink of litigation at that time, and it helped to mitigate against curtailment in the upper basin.
So to take a giant step back now and just kind of think about everything that we just talked about in context. This is a really kind of complex and nuanced system and issue. And the fact of the matter is that we're going to continue to have conflicts because we're looking at potentially increased demands. We are looking at a supply that is going down. So we're going to, again, just continue to have discussions, hopefully not litigation, but conflicts and discussions about how to deal with all this. And when we think about how to deal with it and how to respond to these kind of big issues, to return to our Jenga game here, the approach that we really prefer to take is to really think about all the pieces of that Jenga game as we, pull a piece out or move a piece. We want to think holistically about all of the issues and all the stakeholders and all of the players on the river when we make decisions. And we tend to think that open lines of communication, taking proactive action, those tend to be the best way to manage all of this. We also recognize the need to work within the law of the river, the existing law that we have, like the compact, while also looking at kind of flexibilities and new opportunities in the system, especially given the hydrology that we've seen in the last 19 years. So the other option is that the Jenga game can all just fall down, and we really don't want that. And as lawyers, a lot of things they now think about is the risk of interstate litigation and what that would look like. The U.S. Supreme Court is really great for a lot of things, but we have no idea what we would get from them if we were to take this to litigation. And when you think about it in the context of Arizona v. California, for example, it's kind of scary to think about what could happen. Not to mention the very long amount of time it would require to actually litigate this type of case, the cost to the state and to the other states, and also it just kind of puts a hold on actually managing the river. So our goal is to avoid that, to keep the blocks upright, and to do everything we can to proactively manage this resource that is so important to our state and to other states. And I think that's all we have right now. So with that, we'll take any questions that you all might have. And I would welcome Karen and Lane back up here for that.
That was really helpful, guys. Are there any questions? Yeah, Director Trick.
I just have a comment. Thank you for that presentation, everybody that just presented, all of you. This is a very complicated subject, and you guys distilled it down into a very absorbable flow there. So thank you so much, and I'm sure you're going to have to repeat some of these concepts as we continue to talk about all these issues, but great presentation, thank you.
Thank you. We'll be here.
Yeah, and can we get your slides? Yeah. I would like to memorize them. Are there any other questions for the team? Oh, yeah. Great. Thank you guys so much.
Thank you. Thanks.
Heather? if
Yes,
I might.
Director Anderson.
I would certainly echo Director Kurt's or Trick's thoughts there. Are we free to share the brief that you put together?
Yes, the background materials that you got, there's nothing, everybody knows what that says. I mean, in the sense of they might not have said it the way we wrote it down, but the issues are the issues. There's not something written in there that is the executive session portion of this discussion will be coming in the executive session. And that part, while it's an attorney-client communication, what I've been trying to say in that component is that it is a reference document for you guys to refer to, and it's not a problem. It's just not an official document. It's not a law review, it's not anything. It's just kind of a general kind of reference document for you.
Okay, thank you.
Question. Director Schwartz.
So these slides.
Yes, yeah. Yep.
All right, unless there's further discussion or questions, Director Brown.
I just want some clarification on this matter. Can you please clarify? We received an email with executive session confidential all over it. You're saying we can share that?
Okay, so yes, I would say, and I want to highlight, and I will absolutely defer to Director Beatty, when we are sending something to you in preparation for discussion and it's from an attorney to you guys, you need to consider it to be confidential in executive session. What I'm saying to you guys, as we've heard or whatever, that particular document that you have, I'm not concerned about.
Okay. Any other questions or discussions on that matter? Okay, it looks like we are on to agenda item 14, which is the Attorney General's report and briefing and executive session.
So hello, everybody. Director Weiser, sorry to miss today, but he looks forward to joining everyone at the meeting in November. As you know, the Attorney General's report is in the board's materials, and our team is here, and we are happy to respond to any questions on the report before we move into the topics that are to be considered in executive session. Seeing no questions, we'll now move to executive session. So pursuant to, we are now at item 15. So pursuant to statute, I recommend the board, oh, sorry, we are not yet. Pursuant to statute, I recommend that the board make a motion to go into executive session to consider items 15A through D as identified on the board's agenda. This executive session is authorized pursuant to the provisions of sections 246402 3A2 and 3 of the Colorado Revised Statutes, which allow the board to enter into executive session for conferences with attorneys representing the board to discuss disputes that are the subject of pending or imminent court actions, to discuss specific claims or grievances, or to receive legal advice on specific legal questions. We need a motion.
Director Brown.
I make a motion that we go into executive session.
It's been moved by Director Brown and seconded by Director Goebel to enter into executive session.
During executive session was limited to those items and no
Seeing
formal
none, we'll
action
proceed
was
to vote.
taken.
All those in favor
We are
signify
now
by saying
out
aye.
of executive session.
Aye. Those opposed? Motion
Okay,
carries.
we are
at agenda item 17, but recognizing that 17 is kind of a precursor for a much more important party. It's been suggested from my colleagues in the hall that we move 17 to tomorrow morning and go ahead and adjourn or go into recess for the day. Is there a process to move 17 to tomorrow? Is that fine with everyone? Great. So let's go into recess and we'll move 17 to tomorrow sometime. So now at this point, if everybody just wants to carpool over to the airport, which is
To make a motion.
I don't think we have to make a motion to go into recess. We are in recess.